Why wouldn't the defense simply admit liability and then just move on and try damages? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney. Today I'm shooting video in Asheville, North Carolina, and I have a few minutes to share this great information with you. I had a case recently where it was clear-cut that the defense clearly departed from good and accepted medical care. There was no issue about it. In fact, the defense attorney even recognized and agreed and acknowledged the fact that his doctor, his client, departed and violated the standard of care. So I said to the defense attorney, I said, listen, now that you recognize and acknowledge that your client departed from good and accepted care and violated the standard of care, let's just admit that and now move on. We'll try this case solely on damages, on the harms and the losses that your client caused my client to suffer. And you know what he said to me? He said, I can't do that. I said, why not? He said, we can't do that because my client is a nice guy. I want the jury to see that my client is a nice guy and didn't really intend for this to happen. I said, that's not the point. The point is we'll be wasting everybody's time by trying this case on liability. When it's clear-cut, you've admitted to me that it's obvious. The only real issue here is how much money to award to my client. So let's not waste everybody's time. Let's just delve right into the harm and losses that my client suffered as a result of your client's carelessness. And you know what he said? He said, I can't do it. I need to have a full trial so that the jury can see that my client is not as bad a guy as you portray him to be. Now, in my opinion, I think that's a bad strategy. If he simply recognized, acknowledged, and admitted to the jury, to the court, that his client was responsible for my client's injuries, I think that would be a much smarter strategy, and now we wouldn't have to waste the court's time or the jury's time focusing on liability, proving who's responsible in the case, proving who is more likely right than wrong, and showing that the doctor did something improperly that caused my client harm. Why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on sometimes when there's clear-cut liability, where the doctor should be accepting responsibility, but because of strategic reasons, he chooses not to. You know, I recognize you probably have questions of your own about your own medical malpractice or accident case in New York. Well, if your matter happened in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. This is something I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.